8. Restitution or restoration. God's purpose in redemption is the restitution or restoration of all things in, through, and under Jesus Christ as King. Acts 3:21. The goal of history is the great regeneration, or new Genesis, of all things in Christ. Matthew 19:28. Quote, "The times spoken of by the prophets are here described as times of restoration, when Christ shall reign over a kingdom in which none of the consequences of sin will any longer appear." End quote. Wright observed of the word restoration that, quote, "Round this word gather some of the most fascinating problems of our thought in regard to the possibilities of human destiny." End quote. It involves the declaration that humanity is to be restored to blessedness, and the earth blessed together with man. This restoration, or restitution, does not mean universalism. The principle of restitution is basic to biblical law. It appears with especial prominence in laws under the 6th and 8th commandments, but it is basic to the purpose of the whole law. The eye for an eye, tooth for tooth concept is not retaliation, but restitution. Not only liberal, but evangelical scholars often err at this point, as witness the premillennial dispensationalist scholar Unger, who reads Exodus 21:24-25 as literal and as vengeful retaliation. But the very context of the passage cited militates against this. A pregnant woman who is struck by a man, although unintentionally, is compensated by a fine. If harm follows to either mother or child, the man pays with his life. Is this retaliation, or is it restitution? Exodus 21:22-25. The passage which immediately follows, Exodus 21:26-36, again sets forth the principle of restitution, usually by compensation, unless death ensues. To read the eye for an eye principle as the literal blinding of a man who has put out another man's sight is to do violence to the plain statement of Scripture. The same applies to Leviticus 24:17-21. The restitution for some offenses is capital punishment, for others, compensation. Some of the laws of restitution have reference to damages. Clark's summary of the biblical law of damages is excellent. Quote, "The law of damages is that one who injures or wrongs another shall make reparation or restitution. Rules concerning the duty of restitution and the amount or measure of damages are stated in the Scriptures. Thus, restitution is required of a thief, Exodus 22:3, of one who causes a field or vineyard of another to be quote-unquote eaten, Exodus 22:5, of one who kindles a fire which escapes and burns stacks of corn, or the standing corn, or the field of another, Exodus 22:6, of a bailee from whom an animal delivered to be kept is stolen, Exodus 22:10 and 12, and of one who kills an animal belonging to another, Leviticus 24:21. One who commits an assault upon another with a stone or with his fist is required to pay for the loss of his victim's time and to cause him to be thoroughly healed, Exodus 21:19. The owner of an ox that gores another's manservant or maidservant is required to pay 30 shekels of silver to the master, Exodus 21:32. And the seducer of a damsel is required to pay 50 shekels of silver to her father, Deuteronomy 22:29. Similarly, a husband who slanders a newly married wife is required to pay 100 shekels of silver to the wife's father, Deuteronomy 22:19. End quote. Some of the categories of damages are as follows. 1. For maiming persons, Exodus 21:18-20, Leviticus 24:19. 2. For killing animals, or an animal killing another animal, Exodus 21:35-36, Leviticus 24:18 and 21. 3. For various wrongs committed, restitution to God, Numbers 5:6-8. Many other laws of restitution deal with property. Our concern here is with injuries to persons primarily. Certain principles of liability appear. First, the guilty party is liable for the medical expenses of the injured. He shall cause him to be thoroughly healed, Exodus 21:19. Second, the guilty party is liable for the time lost from work, Exodus 21:19. If the guilty party were an owner and the injured party was his slave, then there was liability for death or for injury, but not for time lost, since the loss was the loss of the owner. He had, at this point, damaged himself, Exodus 21:20-21, Leviticus 24:17-20. Third, the penalty applied if an animal owned by a man were guilty of the injury. If the animal had no previous record of violence to man, then the animal died, and of course the injured person was cared for and compensated. But if the animal had a previous record of violence, the owner now became liable to the death penalty for murder, Exodus 21:28-29. Fourth, the guilty party is liable to the damages laid upon him by the court for the injury, in addition to compensation for time lost and for medical expenses. The principle of restitution is not entirely gone from law today, but there are significant differences. A study of the subject by Stephen Schaeffer is important in this context. According to Schaeffer, quote, "The guilty man, lodged, fed, clothed, warmed, lighted, entertained, at the expense of the state in a model cell, issued from it with a sum of money lawfully earned, has paid his debt to society. He can set his victims at defiance, but the victim has his consolation. He can think that by taxes he pays to the treasury, he has contributed towards the paternal care which has guarded the criminal during his stay in prison." These were the bitter and sarcastic words of Prins the Belgian at the Paris Prison Congress in 1895, when during a discussion of the problem of restitution to victims of crime, he could no longer contain his indignation at various practical and theoretical difficulties raised against his proposals on behalf of the victim. End quote. Restitution has long been in the background of virtually all legal systems and at times been very prominent. Thus, under early American law, quote, "A thief, in addition to his punishment, was ordered to return to the injured party 3 times the value of his stolen goods, or in the case of insolvency, his person was placed at the disposal of the victim for a certain time." End quote. In modern law, the term restitution is usually replaced by, quote, "compensation," or damages. But the significant difference is this. In biblical law, the offender is guilty before God, and hence restitution is due to God, Numbers 5:6-8, and before the offended man, to whom he makes direct restitution, whereas in modern law the offense is primarily and essentially against the state. God and man are left out of the picture in the main. According to Schaeffer, quote, "It was chiefly owing to the violent greed of feudal barons and medieval ecclesiastical powers that the rights of the injured party were gradually infringed upon and finally, to a large extent, appropriated by these authorities, who exacted a double vengeance indeed upon the offender by forfeiting his property to themselves instead of to his victim, and then punishing him by the dungeon, the torture, the stake, or the gibbet. But the original victim of wrong was practically ignored. After the Middle Ages, restitution, kept apart from punishment, seems to have been degraded. The victim became the Cinderella of the criminal law." End quote. The idea of restitution was severed from the concept of punishment. Quote, "The theory developed at the end of the Middle Ages that crime is an offense exclusively against the state had severed that connection. The concept of punishment remains untouched by the civil concept of restitution." End quote. In fact, Schaeffer noted, quote, "If one looks at the legal systems of different countries, one seeks in vain a country where a victim of crime enjoys a certain expectation of full restitution for his injury. In rare cases where there is state compensation, the system is either not fully effective or does not work at all. Where there is no system of state compensation, the victim is, in general, faced with the insufficient remedies offered by civil procedure and civil execution. While the punishment of crime is regarded as the concern of the state, the injurious result of the crime, that is to say, the damage to the victim, is regarded almost as a private matter. It recalls man in the early days of social development, when, left alone in his struggle for existence, he had himself to meet attacks from outside and fight alone against his fellow creatures who caused him harm. The victim of today cannot even himself seek satisfaction, since the law of the state forbids him to take the law into his own hands. In the days of his forefathers, restitution was a living practice, and it is perhaps worth noting that our barbarian ancestors were wiser and more just than we are today, for they adopted the theory of restitution to the injured, whereas we have abandoned this practice to the detriment of all concerned. And this was wiser in principle, more reformatory in its influence, more deterrent in its tendency, and more economic to the community than the modern practice." End quote. Certain things appear from the foregoing. First, the shift from restitution to imprisonment has its roots in the seizure of power by church and state, and was in its origin designed to shake down the guilty for ransom or confiscatory purposes. Second, the state made its doctrine of punishment the criminal law and relegated restitution to civil law. Thus, if an injured party seeks restitution today, it involves the expense of a civil suit through the medium of an essentially uncooperative court, so that even if the injured party wins, collection is very difficult. As a result, because of this division, the criminal faces prison, a mental institution, or a correctional facility, and care by an increasingly indulgent state, rather than restitution. Third, since one form of biblical restitution was the right of self-defense, the right under certain circumstances to kill the aggressor or thief, the increasing limitation on the right of the injured to protect himself, means that we are returning to barbarism without the protection barbarism involved, that is, freedom to defend oneself. Fourth, the systems of imprisonment or rehabilitation of criminals involves, in fact, as Prinz noted, a subsidy to criminals and a tax on the innocent and the injured. It is thus a further injury to the godly, which requires restitution from the hands of God and man. A society which subsidizes the criminal and penalizes the godly will end up by encouraging increasing violence and lawlessness, and is thus destined for anarchy. Fifth, Wines noted, while giving us the false source as the preferred one, quote, that there are but two possible sources of civil power, namely God and the people. End quote. If power is from God, then God's law must prevail. If power be from the people, then the people's will shall prevail, and there is no principle of law above and over the people. Restitution as a principle is thus alien to a democratic society, because it is a theocratic principle which requires that man conform to an absolute and unchanging justice. Restitution as a theocratic principle involves three things. First, it involves restitution to the injured person. Second, since the law order broken was God's law order, where no person existed, in the event of death to whom restitution could be made, it was made to God. Numbers 5, 6 through 8. In cases of sin where God was directly involved, a fifth part was added in the restoration. This fifth part represented 1/4 of the original amount, another fourth, in other words, Leviticus 5, 14 through 16. In every case, restitution had to be made to God by offerings of atonement, Leviticus 5, 17 through 19. Third, it is apparent from these case laws that restitution is always mandatory for a society to be healthy before God. This carries the implication that the state must make restitution to the injured persons whenever and wherever the state, as the ministry of justice, fails to discover the offending party. The goal of godly society is restoration. At every point, it must be effected with evil penalized and the godly defended by restitution. The goal is central to the faith and to prayer. The Lord's Prayer declares, "Thy kingdom come, thy will be done on earth as it is in heaven." Matthew 6:10. This is plainly a plea for restoration, and all true prayer must incorporate it. The failure of a society to ground itself on restitution, or its departure from this principle, means a growing necessity for costly protection by means of insurance. Much insurance is all too often a form of self-restitution, in that the buyer pays for protection against irresponsible people who will not make restitution. The large insurance premiums paid by responsible persons and corporations are their self-protection against the failure of the law to require restitution. Such a society cannot in good conscience pray, "Thy kingdom come," because it denies that petition by neglecting God's law. The premillennial dispensationalists who deny the law and therefore refuse to pray the Lord's Prayer are thus more consistent than the millions who use it regularly without making any effort to restore God's law order.